Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Well, today is my final word on the Paltrow case. We're going to do a little bit of a post-mortem on that coming right up. So stay tuned. I'll see you down at the beach. So in looking at this, I want to talk about 5 things. I want to talk about the opening statements. I want to talk about the choice of lawyers. I want to talk about the order of proof. I want to talk about the witness dynamics. And finally, I want to talk about the closing arguments. And in that order is what we're going to do. Let's take a look at the opening statements. One of the very first things that you do in a case, once you get into court, after you've got the jury seated, is your opening statement. Now, at this point, by this time, you have been through the entire case. You've had the initial consultation with your plaintiff. You've done an investigation. You've filed a lawsuit. You've taken depositions. You've gathered all kinds of medical records. You've cross-examined the other side. You've gotten all of their witnesses. You know that case backwards, forwards, and sideways. You have to communicate that knowledge to the jury in under an hour. And basically what you're doing is telling them what the evidence will be. You can't argue your case. A lot of times neophytes and novices will say, well, it's an opening argument. No, it's not an opening argument. It's an opening statement. So by the time you get to the opening statement, you know your case. You know it backwards and forwards. And your job is to get up and communicate to that jury why they should find for your client, because this is what the evidence is going to be. And you go into that evidence, you go into it in as much depth as the time permits, and then you say, now the other side gets a chance to tell you their side of the story, and I want you to listen to them too, because you want to emphasize that it's a fair fight, right? Everybody gets a chance to speak. But what you don't do is get up there and not be able to, well, watch this.
Ladies and gentlemen, distracted skiers cause crashes. Defendant Gwyneth Paltrow knew that looking up the mountain and to the side.
Counsel, you need to use a mic.
Just, it's right here.
Let's use it. Testing. It was very faint on the.
Your Honor, while we're doing that, we should be clear that no witnesses at the trial are permitted in this courtroom. I'm not keeping track of everyone, but the exclusionary rule applies.
Exclusionary rule will apply, meaning that anyone who will be a witness in this case cannot sit in and listen to the case before they testify. So if there's anyone here that's a witness, you'll need to leave the courtroom now. Thank you. Did we get it operating? Okay.
Start again. Ladies and gentlemen.
Still can't hear.
Oh, well, let's try this.
Okay, sometimes technical issues do get in the way. You have a problem with a microphone or something like that. But what you cannot do is look inept or make it look like the fact that your microphone didn't work rattled you. And I think that's what he communicated here. And then, even after he got started, well, again, watch.
There are 2 instructors, ski to the left. And the 2 instructors are Eric Christensen and Carrie Oakes. Miss Paltrow skis down to the right. She turns her head up to look at her children. As she turns her head back down, she screams. Then skis back into the back of Terry Sanderson. She rides back down. They hit the ground hard, and Miss Paltrow bounces off of Terry. The weight of both of them, their bodies, caused Mr. Sanderson's rib cage and his arm to smash into the ground breaking 4 of his ribs, 2 of them completely. Sanderson's helmeted head hits the ground, causing a concussion as his brain strikes the inside of his skull. Sanderson
He is reading to the jury from a notebook. Now, if you know the case and you know it backwards and forwards, and hopefully you have rehearsed it, well, then you don't have any need to read from a notebook or even have notes or shuffle papers or any of that. What you do is you get up there and you deliver your opening statement in a clear and cogent manner from the cuff, because nobody knows this case better than you. That is your one chance to make a great first impression, and if you blow it, you'll spend the rest of the trial trying to make up for it. And I think that's essentially what happened here. Now let's talk about the choice of lawyers. My understanding is that the lawyer who did the opening statement, it was his case, and Mr. Sykes helped him. The woman who came in and did Ms. Paltrow and also put Mr. Sanderson on, my understanding is she was hired by the insurance company that is defending the Paltrow counterclaim. They are only going to have to pay $1 worth of damages, but they are going to have to pay attorney's fees, and that's going to amount to a fair amount of money here. So they should have selected legal counsel that has been around the block once or twice. And in this examination of Ms. Paltrow, well, let's just say that doesn't come across clearly.
Hit over the head with all of that information since the time, right?
Indeed.
Okay. So let's talk about those things. Did you know the rules at the time of the collision, that if you're in a collision with someone, you need to give your name and information, contact information?
So because I was hit by Mr. Sanderson and he was at fault, I assumed that Eric, who was our ski instructor who was there at the time, who was overseeing the event, he said, I'm going to leave all of your information. And he said, you should go ski down because my kids were waiting for me.
And I appreciate that, but my question was, did you know of the rule of skiing if you are in a collision that you need to share that information?
Your Honor, this is irrelevant. This is not part of their negligence claim.
Overruled. I've overruled. Go ahead.
Can you repeat the question?
Absolutely. At the time of the collision, were you aware of the rule that if you're in a collision, you need to share your name, your contact information with the person that you're involved in a collision with?
I don't think I was aware of the rule.
Okay. Were you aware that there is kind of a rule of common decency to do that?
I would not have left the scene without leaving my information, and my information was left.
Did you provide that information?
No, Eric Christensen, who was the ski instructor with us, said he would leave all the information.
You don't know if he did or did not, though, do you? You weren't there when he did.
Well, subsequently, I know that he did.
I'm not asking that. I'm asking, when you were there at the collision, you didn't ensure that it was given. You weren't there when it was given.
I was not there when it was given.
Okay, so I don't think she did a particularly good job with Ms. Paltrow. Even more important than that, the flow of how the story is told is completely screwed up. Can you imagine if instead of Star Wars starting off with that line of text that moved up through the lens of the camera telling you about a new hope and it's a time of rebellion and all of this, can you imagine how it would have been if it just started with the cantina scene? You know, the one, that one. Imagine if that's where Star Wars started and it had to fight its way out to the end of the thing with the Death Star. Or worse, it went from that to the Death Star and then back to Han and Luke and Leia being trapped in the garbage disposer. Imagine if the order of all of that story was completely inverted. That's what you had here. They put Paltrow on first. She told her side of the story before the plaintiff ever got to tell his. And I believe that was a terrible mistake on somebody's part. And then the witness dynamics. I think that there are only 2 really important witnesses here. One of them was Paltrow, the other was Sanderson. And watch how Mr. Sanderson tells his story.
What happens next?
You know, I got hit in my back so hard, and I'm right at my shoulder blades, and it felt like, and was perfectly centered, and the fists and the poles were right there at the bottom of my shoulder blades. Serious smack. Never been hit that hard, and I'm flying. I'm absolutely flying.
Now, you're not airborne.
Well, all I saw was a whole lot of snow, and I didn't see the sky, but I was flying in that sense. I had no control. And I remember just thinking, okay, you really got to hang on. And then I thought about the crowd on the left, and I thought, I don't know who's wanted over there, and I do not want to get them mixed up in here. And I've heard, that maybe that's not decided about how my ribs really got hurt. I absolutely lurched what little I could off of my skis a little bit more to the right to make sure nobody over here got involved on my left side. And then it was like the ground's coming up, nobody in front of me, just me going to the ground, and you're falling far further than 90 degrees like you'd fall on the floor. You got that extra. And so it's quite a ways to hit the ground. And I just said, okay, you got to protect your face, and your head. And that's the last thing I remember. It didn't happen. I did glance over and saw, just out of the corner of my eye, I could see, not glance over, but I could see.
Now, again, I think that the lawyer did a much better job putting him on than she did putting on Ms. Paltrow. But again, he's batting cleanup. He's coming into this at the end. His dictation of what happened is not particularly favorable. I think there are some fairly significant problems with how this entire story is being told. After all of that, we then get to the closing arguments. Now, the closing arguments are where you really go after, you pound the evidence, you tell the jury what the evidence means. One of the things you can do on closing argument is ask questions that illustrate problems with the other guy's story. Is it really possible? Do you really think that Ms. Paltrow could possibly have been watching where she was going when she was watching her kids ski? You emphasize that, and you turn your head at the same time, to illustrate that. Those are the sorts of things, those are the sorts of questions that have some merit. But in this particular case, everything about the closing argument was sort of short-shrifted from the beginning by Mr. Sykes' inability to maintain his oratory. In fact, if you watch this, the first few moments of it are quite uncomfortable because you have to listen to him cough.
And she believes it. It's a sincere belief. She's not a liar because of it. Pardon me. But the problem is, a sincere belief doesn't make it so. Now, excuse me.
Then he tells this completely unrelated story to the jury.
On the inside lane of 17 South. I said, my goodness, he's going to hit that woman. He's making that turn. And sure enough, smacked her and smacked her hard. Okay. Now, that's no fun. But it shows you something happened. She writes disoriented, rib pain, loss of consciousness. By the way, Alina,
Contrast that painful closing argument with Mr. Owen's not so painful closing argument.
I'm Gwyneth's lawyer. I'm her spokesman this week. So she sat there for 2 weeks and been a punching bag. We've blown through a lot of these cute little Post-it notes where she's sending me stuff. But I take it very seriously because she's comfortable in a lot of worlds I'm not comfortable in. But she is not comfortable in this world. It is not a nice thing for someone to throw a press conference and say, like King Kong, you knocked him out and walked away, skied away. That is not what happened.
So, again, he told the jury at the beginning he was sorry about the cough, but, he didn't get advance warning of when this cold was going to come. And that's true, I'm sure. But it's also true that Nothing stopped him from stopping by Walgreens or CVS on the way in to pick up a thing of Paul's mentholyptus cough drops so he wouldn't be Mr. Hackenspitz on the stand. At the lectern. So it's really it's a discourteous move. It shows a lack of respect for the jury to sit up there and hack into the microphone. And again, what happens here is you get an accumulation of errors and an accumulation of turnoff, and that's why it only took 2 hours for the jury to reach its decision. I'm pretty sure everybody was agreeable up at the front, and they just went through the evidence sort of as a check on their thought processes. I think this was a very badly tried case from the plaintiff's side. I thought that the defense made some significant missteps in the case, mostly by virtue of Mr. Owen's sort of off-putting personality in front of the jury. The defense got its sea legs pretty quickly and leveled out and did a very workmanlike job, with Mr. Egan carrying a large part of that burden. And I thought he did an excellent job. But that's what I have for you today. That's sort of a brief review and overview of what I thought went wrong for the plaintiffs. I could go through and explain what I think went well and went poorly for the defense, but it hardly matters because the defense won. So if you have any questions, please leave them in the comments down below. Like, share, subscribe. Thank you very much for watching. Again, if you have an opportunity today, take a moment to do something kind. Remember, kindness is never repaid. It's only passed on. So if you've been the beneficiary of kindness, please make sure to pass it on to someone else today. Thank you again for watching. Have a marvelous day, and we'll catch you down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.